I'm going to stick to a few little things, move it along a little bit. A little bit about the structure of the Workers' Comp Commission. A little bit about how we like to see claims investigated to help us, help me with defense. And then just a couple of case law scenarios on slip and fall accidents. The structure hasn't changed too much over the last 25 years. In Chicago, there's 13 arbitrators, downstate venues, and you'll see them all listed here. There's 18 arbitrators. The arbitrators are appointed by the governor. They serve a 3-year term. There's also commissioners who sit above the arbitrators, and they're appointed by a commission panel. But nothing's really changed as far as the structure. Some of the minutia, we don't need to get into that. But this is essentially who's hearing the claims. Why are these guys here? I'm often asked whether the judge, the arbitrator, the commissioner, whether they're liberal or conservative. Well, the arbitrators are appointed by the governor. So over the last 4 years, things have gotten, that arrow's pointing more towards the conservative, which is obviously good news for me, good news for you. It still depends on the arbitrator, their political positions, their appointed positions, but the trend has been more towards the conservative. I think that goes for interpretation of law, interpretation of the accident facts, as well as settlement amounts. In 2011, there was an amendment to the Act. I think there were some good things done there as far as carpal tunnel claims, as far as wage differential claims, a little bit with the fee schedule, a little bit with alcohol and drugs, as far as interpretation of the Act and when you can assume or presume that alcohol had something to do with the accident. So that started in 2011. I think under this governor, things have gotten more conservative. In Illinois annually, this isn't exact of course, but I think I took this from the 2017 commissioner report to the governor. Approximately 200,000 work-related accidents in Illinois every year. Only 40 of those are filed at the Workers' Compensation Commission. So, or 40,000, did I say 40? 40,000. So you can see that not every accident's reported. Maybe those are medical only claims, okay? Maybe those are settled without going to litigation. But of those 40,000 claims at the commission, only 1,000 actually ever go to trial. Maybe of that 40,000, 5,000 are dismissed because they were fraudulent or maybe couldn't prove their claims. Many of those are settled, and I'll talk about that. And then 1,000 claims go to the arbitration cycle and go to trial.
Barry,
Yeah.
who files that with the IWCC?
Who files those claims?
Yeah.
So those claims,
By an attorney?
very few are pro se, meaning they did not have an attorney.
Right.
People still can do that. Illinois is pretty litigious as far as workers' comp claims are concerned. But of that 40,000, 99% of those are filed by an attorney. That's where an employer retains an attorney and they actually file a claim with the Illinois Workers' Comp Commission. As I said, most of those are settled. I mean, you can see 1,000 claims tried. And we'll get into that a little bit too. So once a claim is filed at the Workers' Compensation Commission, this sheet here is a typical arbitrator's calendar. And you'll see it's Bloomington, Peoria, Rock Island. And there's 3 arbitrators that sit in that general cycle, okay? So arbitrator Rose Sullivan in January has a status call on the 24th, and then she'll have 4 trial days. And then in Peoria, she'll have a status call on the 13th, and she'll have 7 trial days. So this is just how we're organized. If you talk to your attorney or your claims adjuster and they say, well, the case isn't up for status until such and such date, this is what we mean by that. When a case gets filed at the Workers' Compensation Commission, it's given a number, it's assigned an arbitrator, and then it's assigned a venue. The venue is where the accident site happened, normally. It's a general rule. There's other exceptions to that, but generally, where the accident occurred is where the claim will be assigned, okay? So, that case will come up for diary or on the status call every 3 months. And at that status call is when the petitioner or their attorney can file a motion for pretrial conference, can file a motion for trial. They can file it off call, but not usually. Just as a general rule, every 3 months is when they can proceed to trial. Okay? And every arbitrator has a calendar like this. Chicago has a similar calendar. Looks a little different because they're all in Chicago. They're not running around to all these different places like me. But every arbitrator has a calendar. In Chicago, they have more trial dates because they're all centrally located. Here, some of our arbitrators might not live down here. Arbitrator Granada lives in Chicago. Arbitrator McCarthy lives down here. So the arbitrators will travel down and either stay or go back and forth. But they'll hear trials on all those days. So that's just the basic day-to-day calendar for the cases. So,
Very quick on that.
yeah,
Sorry.
yep.
So usually in those cases when they're up, is that, I mean, how often would a school or an employer show up for those? Or was that totally just in the hands of
Yeah.
accident fund or whoever to represent?
Right.
Schedule that, make sure somebody's represented.
So when do we need a school or a respondent or employee or representative at these status calls? I can tell you, not unless the case is going to trial. There are times where I marched a bunch of people in just to look all tough, that we're going to trial and, but typically I don't like to waste a lot of people's time if a case isn't really going to go to trial. We definitely need and want witnesses and testimony from our employers. But it's not a whole, if you get something in the mail that says, status call date, call your claims representative, call your agent, tell them, I got this paper, I don't know what it means. Everyone here is going to know because I just said it, but you don't need to be there, okay? Unless you're notified, usually by the insurance company's attorney, okay? And simply because you got a notice in the mail that says there's a status call, that does not mean the case is going to trial. Okay? They come up every 3 months. So there's a lot that goes into it before the case ever goes to trial. And believe me, if we needed you at trial, you would know about it. You would know about it well ahead of time. Okay? This is essentially what Pat was just alluding to, the timeline for a disputed claim. So, once the petitioner has a claim, and that's escalated, he has an attorney, I'm often asked, why did he get an attorney? Illinois is litigious, for lack of a better phrase. It's litigious. Joe's uncle's brother got a $100,000 settlement for some crazy claim, and so everyone wants to get their piece of the pie, I suppose. But it could be for a number of reasons. And when I was adjusting claims, I forgot to mention, so I was a claims adjuster out of undergrad for 3 years, and then for workers' comp. And then I went into another company, went to Hanover Insurance for 10 years as a claims adjuster for workers' comp. And then I went to night school, came out of law school, and I've been practicing defense work for workers' comp for the last 17 years. So I just can't get away from it. It's, you know, but, so I've seen it all. I used to tell claims people, try and get control, you know, hold their hand, but once there's a dispute, and they're gonna get an attorney. I don't care how nice you were, how many times you called them, they're gonna get an attorney. So once they get an attorney, the claims representative and the petitioner's attorney usually get together, try and work things out. If there isn't a resolution, it'll be assigned out to me. Yeah?
You mean financial resolution at that point? Because
Yeah.
I have received those calls, the suit, hey, this will cost $1,000,
Right.
$2,000, $8,000. You want to write a check, make it go away. At what point, and I know you'll get to that probably, but that's not now, right?
Right. But yeah, usually it's a resolution either, but it could be about something smaller than the final resolution of a claim. It could be a disputed issue about, are you going to approve an MRI? Are you going to approve physical therapy? My guy was off at work for 2 months, you only paid him for 3 days. You know, what's going on? So there's a lot of things that can come around as part of a claim. And the littlest thing can cause someone to go out and get an attorney, you know. So once there hasn't been a resolution that comes out to me, the problem is sometimes I get involved a year and a half after the claim's been reported to the insurance company. There's been a lot of things that have gone along. I looked at a case last week and it's an older case of course, but I had 7,000 pages of medical records to review. So you could tell how old that case, you know, and I'm like, why did you get me involved 2 years ago? You know, we wouldn't be here. But as I said, sometimes I'm involved way down the road. If there hasn't been a resolution, there can be a trial at the appropriate status call. You saw that there's only 1,000 trials out of the 40,000 cases that are filed. Part of the reason is, let me try one of these. Ooh, look at that. Part of the reason is, it takes a long time to get a decision. From an insurance company standpoint, if we're not paying money at the time and it takes 6 months to get a decision, okay. But from the plaintiff's or the petitioner's standpoint, they don't want to take 6 months to get a decision. There's an arbitrator who I will not name, you cannot make me name him. I had a very simple case that should have taken a month. I got the decision 11 months after we tried to file, okay? So nobody wants that, especially the plaintiff's attorney, petitioner's attorney, who's now gonna have his client screaming at him, we tried the case, where's the decision? Where's my money? So settlement, for a number of reasons, is usually the most preferred option of resolving the file, okay? And another part of it too, not only the arbitrators take a while, so once there's been an arbitration decision rendered, and both parties get the decision back, and one party doesn't like it, they both have a right to file an appeal to the commission. Now that process from there, from the time I receive a decision until it actually gets to a commission, can be up to 6 months, 8 months, 10 months. Okay, so now there was 6 months, let's say, for the arbitration decision, and another 10 months until we get to a commission panel, okay? And then the commission, there's 3 of them, so it's actually a shorter time period to get your decision. But now, if I don't like the commission decision, I could file an appeal up to the circuit court. So of those 1,000 cases that are tried per year, maybe 400 go up to the circuit court on appeal. If you don't like the circuit court decision, you get to go to the appellate court. And you see what, maybe 100 cases or so get appealed up to the appellate court per year. And if you really don't like that one, you can go to the Supreme Court, but the chances are that the Supreme Court's gonna hear your cases very, very slim, very slim. But for all of this here, you can see, that's why I put this here, is to, we often get, why is this taking so long? Why is this case still open? Why isn't it resolved? You can see the timelines, and I didn't even add in there depositions and things like that can really drag a case on. The timeline, if you don't settle a case and you reach an impasse that's impossible for both of you, here's your timeline. I don't add it at all, but maybe 2 years. And if you go all the way up, 3 years. It's just something to think about when you're deciding, okay, the settlement demands $25,000 and we have the case evaluated at $18,000 or $6,000 apart. Are we gonna wait 3 years? Or are we gonna meet them in the middle? Or are we gonna draw a line in the sand and say, we're not paying another dime? So all these things come into play. Defending a claim. So I've been on the claims adjuster side. I've been on the defense attorney side now for 17 years. I know how I investigated a claim when I was a claims adjuster. And I think the teams that I work with now are fantastic. And I think they do a wonderful job. I think sometimes our insureds could drop the ball. None of you, of course. None of you, of course. But we really need help with investigation. Okay. These are just some of the things that I recommend. I mean, I've seen all kinds of books and pamphlets and things like that. These are just some of the things that I recommend, that when I get a file in from an adjuster, and I'm hoping to see statements and things like that, and maybe all I get is that first report of injury with a few lines, and then maybe a supervisor's accident report that I can't even read. It's completely illegible with no date on it. Those things don't help us defend your claims 2 years after the fact. Okay? So, obtain a written statement from the employee. I think if we can narrow his version of the facts down, okay, no matter what he says a year and a half ago or a year and a half later at trial, I can always use that to impeach him on the stand and say, well, wait a minute, the same day it happened, you said this happened. But now a year and a half later, it's conveniently tweaked a little bit to change the story. So obtain a written statement from the employee, obtain a written statement from the witnesses, obtain photos. We all have cell phones now. If there's a crack in the sidewalk, I'd like to see a photo of it, okay? It'll help us later on down the road as far as whether or not we're questioning the accident. Secured any defective materials, ladders, if someone falls in a broken chair. Keep all the documents in a file. This one, it's really easy to keep some stuff. People lose things all the time, especially when you're talking about these claims that drag on forever and ever and ever. People just lose stuff, it just happens. Keep a file, keep a folder, keep a file cabinet, whatever it might be. This one is great. Keep a timeline of events and discussions. There's some HR people that I work with that just start a Word document as soon as an accident happens. Talk to witness, blah, blah, blah. September 1st, talk to the petitioner. September 3rd, he brought in a medical excuse saying he's not coming to work. September 4th, no show, no call. September 5th, no show, no call. September 6th, no show, no call. September 7th, terminated for violating the no call, no show policy. Okay? But this timeline of events really helps us out. And the way it does, I can refresh the witness's recollection down the road. Okay? Because 2 years later, I'm going to call that witness, or I'm going to call that HR person up to testify. And I'm going to say, what happened? What happened? I don't know, sometime in September. He might have said something to somebody, but now I can say, here, this is what you wrote down. Here's all the reports. Here's the witness statements. Now do you remember? Oh, I remember exactly what happened. That makes a way better witness than the person that comes in and says, could have happened, I don't know, not sure. I can't defend those kind of claims. We can defend them, but we can't win. Make it clear. Just 2 weeks ago, I had a guy with a dental injury. He had claimed that using a jackhammer, and it hit him in the teeth. And the adjuster had the file for 6 months or so, and they were denying the claim because the manager said, didn't happen, I don't know anything about it, no one reported it at all. Claim comes to me, there's a filing for a trial, I get the medical records. The first medical record from that day says, employee was using a jackhammer and hit himself in the mouth. And I'm like, how do you even make that up? So I said, we need to investigate this a little more. We need to dig in a little bit more. What's the supervisor's name? What's a couple coworkers' names? The first guy calls it, oh yeah, bopped himself real good in the face with a jackhammer. So there had been no statements from anybody. There had been no plan about getting witness statements, photos, whatever it might be. But in the meantime, a claim was denied for like 6 months when it could have probably been resolved very early on in the process if they had kept a record of witness statements and so on. So help me help you is the point. Help me help you. If we do a really good investigation from the ground floor, we'll have much better success defending claims. Just some of the tools that we use, recorded statements by employees. I think for the most part, when there's a lost time claim that comes in, the adjusters are taking recorded statements. Okay, but again, that might not be contemporaneous with the accident. It might be a week later, it might be 2 weeks later. Okay, so I still recommend written statements from employees. We do background checks, we do claims checks to see how many claims there's been in the past. Also with our checks, we're finding out, at the commission, if we're entitled to credit for prior accidents. So if someone has an accident involving their hand 5 years ago, we're still entitled to a credit for that settlement. There's certain things you're not entitled to, but specific loss injuries, you are entitled to a credit. Background checks, surveillance, subpoenas for medical records, independent medical evaluations. I'm sure you guys have heard that term. That's really our main tool when we talk about causation. There's a lot of accidents where something happens, someone's injured, and we're just not sure if the injury is related, okay? For one reason or another. The accident happened, we know it happened, we're not disputing it, but is that shoulder injury really related? Someone said he was building a shed at home over the weekend. We can't play doctors, so we hire doctors. And we can have them examined. They need to go, they have to go. If they don't go to the independent exam, their benefits are suspended. This has probably happened. That ladder was just too far to go grab, so we pile up some boxes or we step on a stool or something. I just had one where the cleaning lady at a school didn't want to get the step stool, so she used a swivel stool, and of course, she went down hard. So I'm going to talk a bit about slip and fall accidents. I just thought that, again, there's a million hypotheticals we can come up with and sit here all day. But I thought slip and falls, schools, okay, maybe that's something that you guys have encountered. So a fall at work that's caused by a confirmed work-related factor or debris or defect is compensable, okay? So, a tear in the carpet, a crack in the sidewalk, if there's a known defect, it's compensable accident. The problem comes when we don't know what the defect is. So a disputed slip and fall accident, it falls usually into two categories as for us as defense attorneys: idiopathic or unexplained. An idiopathic accident, I'm going to read this, resulting from epileptic seizures, fainting, or some other condition that is personal to the employee are not compensable unless the employment contributed to the injury by placing the employee in a position of increased risk of injury. So, if you have something that causes maybe a seizure, and we'll talk, I'll read a case about a seizure, but a fainting spell, something like that, a really bad knee that you don't tell anyone about, and this risk, this is personal to you, and it's the reason you fell, it's the reason for the accident, it's not compensable. However, the courts go out of their way many, many times to infer a risk, okay, and we'll talk about that. I want to read this case to you, this Prince case, real fast, and I'm almost done. So in this Prince versus Industrial Commission, the petitioner was a known epileptic. He had gone to the basement from the second floor to get a bucket of water. After getting the water, he sat down for a moment to talk to a coworker. When he got up, he had a fainting spell, he had a seizure, and he struck his head on a concrete floor. The commission, rightly so, they found the injuries did not arise out of the employment, rather the accident was caused by a risk personal to the petitioner. And they've held that the concrete floor presented no increased risk or hazard, okay? That almost identical fact pattern was changed in a different case. A guy sat on a chair, didn't feel great, he had been sick the day before, he fell, but he struck his head on a desk that was nearby, and they said the desk was too close to his desk, and he struck his head on the corner desk. That second desk posed an increased risk, and that case is found compensable. Okay, so the facts of every case, every case is different, okay? But if it's truly a risk personal to that employee, it will not be found compensable, okay? The next one is an unexplained fall. So unexplained accidents by definition are without explanation and cannot be deemed causal related to the risk of employment since the cause is unknown, okay? Injuries that are truly unexplained will not be compensable. And this is where I talked about the commission. The commission can go out of their way to infer a risk. And that's usually what happens when you're before maybe one of those judges that I talked about that was more on the liberal side of things, okay? So they can draw inferences from the facts that the accident was caused by a heightened risk, reasonably incidental to the employment. So in this case, William G. Sees, this petitioner fell downstairs while exiting work. The evidence showed that the fall was unexplained. There was no defect or debris on the stairs. The petitioner, however, testified she was rushing to deposit mail because her supervisor asked her to. The appellate court, so this went all the way to the appellate court. The appellate court said that the fall occurred because of the petitioner's hurried departure from work, which caused an increased risk, and therefore they found that the case was compensable. Okay. So you can see I could say all this, but it's still a battle sometimes, right? There's other cases that were about increased risk. Scaffolding. The gentleman had a fainting spell. He fell from some scaffolding. Now the fainting, of course, is not related to the employment, but because he was working at a height that posed an increased risk, it turned out to be a compensable claim. There's a lot of different scenarios that we could go through, but as I said, we could probably be here for a few hours, or days, or weeks, or whatever it is. Well, that's all I have. Anyone have any questions?
I do have one. This is common, happens a lot now. not a lot, but probably more often we like, different events, activities,
Yeah.
Whether it's a work-related function, that there's a team building thing,
Sure.
or a teacher versus student basketball game.
Yeah.
That kind of stuff
Yeah.
is happening a lot.
Mhm.
What legal protection can the district provide or put into place that would alleviate workers' comp benefits in those situations? Could they make the employees sign something that says, we are not requiring you to do this, you're doing it at your own risk? Even from it goes further into a coaching standpoint, whether it's softball, football, basketball, whatever it is, you know, the intent of a coach is to instruct and not to go full bore and play in a football game or you know, in a play or play open gym and basketball or whatever.
Yeah.
So there's injuries happening a lot on that, and when they do, they're big. You know, it's a torn ACL, it's a torn Achilles, shoulder.
Well, you asked two questions. One is about recreational stuff, right? Sort of company-sponsored events, recreational things. And then the other is about maybe some high-risk employees, coaches and whatnot, yeah. Well, with the recreational stuff and talking about maybe having them sign something, this isn't mandatory. That's the whole thing. Is this mandatory? Yes, having them sign something is certainly a piece of evidence. I don't think it carries the day, because there could still be other evidence of coercion, you know,
Right.
that would come into play. Having a piece of evidence saying you signed something, at least that gives us a jumping point to whether or not this was a mandatory situation or not. Now, we would still want to talk to a supervisor, we would still want to talk to other employees. You know, if you didn't go to this event, could you go home? Did you have to work? You know, was there any repercussions for not going to the event? I have a claim now. I hope it's not one of you, but I won't say the school. There was a teacher class talent show, and the talent was they were going to line up a bunch of teachers, and they gave them hard hats, and then they made music by beating on the teachers' hard hats. Okay? Don't raise your hand. Don't raise your hand at that too. So I'm trying to get the actual implement that where they were using to beat on the teacher's head. I don't think it was anything like, you know, a hammer, but it was hard enough that she's alleging she has a cervical injury, and so we have to defend that claim now. And part of that is, was it mandatory that she participate? And part of the conversation was, well, it wasn't really mandatory, but someone said, well, if you don't do this, we can't have a talent show. Sounds kind of mandatory to me. You know, we don't ever want to let the students down, right? So that's going to be an interesting one. And really, I think at the end of the day, that may come down to more about getting an independent medical exam and seeing whether or not this injury is causally related to the like tapping on her head or some other congenital problem, you know. And getting back to your other question about the coaches and whatnot. Some things can't be avoided, right? I had a basketball teacher, volleyball coach on a sideline, and she's run over by the referee, and I mean hard run over, slammed.
It was a basketball thing.
Was it basketball?
Yeah.
Yeah, it was basketball. I was involved.
Somebody's in this room.
Okay, yeah, okay. So anyway, can't be involved, that's not, we're talking about the other things where, you know, a coach gets hurt instructing them on a maneuver of some kind, right? If it's foreseeable and reasonable that that's part of his job description, I think it's a compensable
Sure.
claim.
Yeah.
You know, it's when he's doing the, you
In
know.
the summer, playing up and down with the kids or
No.
whatever. Yeah.
No.
We had one of those
Yeah.
a couple years ago, and it was
Yeah. The language of the cases, the language of those kind of claims are gonna be reasonable and foreseeable.
Yeah.
And it's obviously broad definition, and it's gonna be up to the arbitrator to determine what's reasonable and foreseeable. But that's generally the language that they use.
Okay.
Anything else?
Here, you got a question. Are all the
You're on my team, you're not
I
supposed to
know,
answer
I know.
questions.
Are all the arbitrators attorneys now? I knew for a long time
Yeah.
since they were appointed, a lot of them weren't attorneys.
Right. I'd have to think back about their job description. I will tell you that, and there's some older arbitrators that are still here in Chicago, and they may have not started out as attorneys, but I would say about 90% of them are attorneys. And there's been some conservative appointments in the last 4 years. So we'll see how much longer that goes on, but most of them are. All right, well, listen, I'll leave a couple cards or some cards in the back. If you guys ever have a question, I'm staff counsel with AF Group, so I work with United Heartland, Accident Fund, Third Coast Underwriters. But I'm always happy to answer just a general question you might have about some weird claim that comes up, and you don't know necessarily where it's headed. And of course, if I'm on any of your claims and you see my name, feel free to pick up the phone. I'm always available to talk. All right, thanks.
Thanks, Barry.